This module will provide an information on basic parts of patent document like what is a patent specification. A patent specification is a technical document containing a detailed description of an invention for which patent protection is looking for. This document defines the scope of protection of your invention. It is highly organized, well-structured document to be prepared critically and carefully, preferably with the help of an expert like patent attorney, to ensure that the invention is protected adequately and completely. Next is layout of a patent specification. A patent specification comprises of a description of an invention, a claim or set of claims and drawings if any, and is accompanied by an abstract, which further comprises of several components, say description. The description is a disclosure of the invention. The description generally includes parts such as title of the invention. The title is required to indicate the subject matter of the invention in a clear and concise manner. Technical field of the invention, which specifies the technical field advances for which the invention related to. Background art, an indication of any relevant background art known to the applicant, which can be regarded as useful to the understanding, search and examination of the invention. Any known published documents reflecting such art may also be cited, where possible. Disclosure of the invention. This section provides an explanation of the invention in a manner sufficiently clear and complete for the invention to be evaluated and carried out by a person having ordinary skill in the art. Also, any advantageous effects of the invention with reference to background art must be stated. Description of the drawings. Where drawings are included, a brief description of each figure of the drawings is required to be provided in this part. Preferred embodiment of the invention. This part is a description of the best mode of the invention speculated by the applicant for carrying out the invention, with reference to examples where appropriate and drawings, if any. The best mode or preferred embodiment of the invention basically refers to the best way known to the applicant to carry out the invention. Industrial application. When it is not obvious from the description or nature of the invention, it is advisable to indicate specifically the way in which the invention is industrially applicable. Further, patent claims define the scope of the protection conferred by the patent. The rest of the patent is there to facilitate understanding of the claimed invention. It is therefore crucial to ensure that the claims are drafted with great care to provide the invention adequate protection. Then, drawings. Drawings in the specification have to be incorporated to understand the invention more clearly. They may be in the form of flowsheets or diagrams. Then drawings in the specification have to be incorporated to understand the invention more clearly. They may be in the form of flowsheets or diagrams. And finally, abstract. The abstract embodies a summary or concise description of the invention in about 150 words or less, which gives a general overview of the invention. In a nutshell, the abstract should indicate the technical field of the invention, the existing technical problem, the upshot of the solution to the problem through the invention and the principal use or uses of the invention. The abstract also serves as an efficient tool for the purpose of searching in a particular technical field. Patent is one of the most complex scientific techno-legal documents. Here in front of you so-called Malaysian patent. It consists of description or text of disclosure along with claims, drawing and abstract not exceeding 150 words. A patent agent appointment form, that is Form 17. Applicants, name, address and nationality. Inventors, name, address and nationality of each inventor. Statement justifying applicant's right to the invention if the applicant is not the inventor. This may be a brief of informal statement explaining on how the applicant acquired the rights to the invention. Priority claim under the Paris Convention, Basic Applications Number, IPC, filing date, international patent classification and country where filed. Drafting of patent specification is a tool of great importance and thus should not be left to a layman to design it. The person who writes application must have the capability of understanding the area of invention, so that he would be able to draft the application to meet the patent application requirement. It is extremely important to use carefully selected language to describe an invention to satisfy requirements both in legal terms as well as in technical terms. Selection of the right words may prove tricky when the draft person is an amateur. Unclear and indefinite languages used in the specification are always likely to draw competitors, or any person concerned to invalidate or oppose the patent or the patent application. And not only is the language significant, satisfying the requirements of patentability is equally vital. In general, patent applications are drafted with the help of patent attorney or patent agent who has the technical background as well as legal background or patent law expertise. Patent procedure. Before getting into procedures, I would like to introduce you the background of Malaysian patent system. The Intellectual Property Corporation of Malaysia, also known as MyIPO, is an agency under the jurisdiction of the Ministry of Domestic Trade, Cooperative and Consumerism, which is responsible for the development and management of the intellectual property system in Malaysia and responsible for the development and management of the intellectual property system, which includes patents, trademarks, industrial designs, copyright, layout designs of integrated circuits and geographical indications. The historical background says that patent prosecution in Malaysia is governed by the Patents Act 1983 and the Patents Regulations 1986. These legislation, which came into force on 1 October 1986, marked the beginning of an independent patent registration system for Malaysia. Before 1 October 1986, to granting a patent protection in Malaysia, candidate needs to secure a patent registration in the United Kingdom and subsequently re-register the same in Malaysia. The re-registration would provide the registrant in Malaysia the same privileges and rights as that conferred in the UK as if the patent had been granted in Malaysia. The earlier system of re-registration of UK patents has since been repealed. The services offered by MyIPO includes a registration of patents and certificate for utility innovations, trademarks, and all related aspects of IP. Advisory and consultancy services on IP. Providing IP information and statistical data. Conducting training and outreach programs. Conducting patent agent examinations. Providing online services, that is online databases search, filing and tracking application status, through the Patent and Trademarks Administration System known as PANTAS. A patentee need to follow various stages of patent applications that includes 1. Filing of application. Applicant needs to fill the Form 1 in a prescribed format along with stipulated fees for the official filing. Examiner at the Registry of Patents will check the application to ensure that the minimum filing requirements have been fulfilled. If so, the registry will issue the application an official filing date that is known as priority date. Subsequently, a certificate of filing bearing the official filing date and the allotted patent application number will be issued to the applicant. 2. Preliminary examination. Within 18 months from the filing date, the applicant is required to file Form 5 together with the fee of RM 1100.00 to request for a substantive examination of the application. The application will then be subjected to a preliminary examination whereby the application will be examined to check whether the application is in line with the formal requirements or not. If there is any deficiency, a preliminary examination adverse report indicating the non-compliances will be issued, giving the applicant a period of 3 months to address the deficiencies and respond to the same. Failure to respond to the report within the given time frame will deem to be rejected. 3. Public inspection. After 18 months from the filing date or the earliest priority date, details of the filed patent application, including the complete specification, are made available for public inspection. The application, however, is not published in printed form. 4. Substantive examination. The next step is the filing of the request for substantive examination, either full examination or modified examination, or the request to defer the request for substantive examination, which must be made within 2 years from the filing date of the application. Failure to do so within the stipulated time frame will result in the application being deemed as withdrawn. The request for full substantive examination is made on Form 5, whereas for modified examination, the request is made on Form 5A. The prescribed official fee must be paid at the time of filing the request. As for the deferment of substantive examination, the request needs to be made on Form 5B. There is, however, no payment required for the request for deferment. During the substantive examination stage, the patent examiner will conduct a search and examination of the application to ascertain if the invention is registrable and in compliance with Malaysian patent law. If the examiner has objections, a substantive examination adverse report indicating the nature of the objections will be issued, giving the applicant a period of 3 months to respond to the same. Failure to respond to the report within the given time frame will result in the application being refused. In some cases, subsequent substantive examination adverse reports may be issued if the objections raised in the earlier report have not been addressed to the satisfaction of the examiner. However, if the examiner is satisfied that all requirements have been met, or the objections have been overcome, a substantive examination clear report will be issued and the applicant will be requested to pay the registration fee within 2 months. 5. Registration. Upon payment of the registration fee, a certificate of grant will be issued and details of the same will be recorded in the Register of Patents. Also, the particulars of the patent, together with the abstract, will be published in the Government Gazette. This flowchart will give you a very real picture of the whole patent procedure from filing till granting. Important fees and forms are tabulated herein. Let me define each of them. F1 form is used for request for grant of patent with its claims with a payment of 200 Malaysian ringgit. 10 per each claim. Form F2 is required for declaration of withdrawal of application of patent without any fee. Form F5 is for request for substantive examination with a payment of 700 ringgit. Form F5A used for request for modified substantive examination with a payment of 450 ringgit. Form F16 is required for request to amend application for grant of patent with a payment of ringgit 50. Form F18 is used for application for registration of patent agent with the payment of 2,000 ringgit. Form 18A is required for application for registration as candidate for examination with a payment of 100 Malaysian ringgit. Here is the location maps of MIPO with different offices. Headquarters of MIPO is located at Kuala Lumpur. Southern office is located in Johor Bahru. East Coast office located in Kelantan. Northern office is in Penang. And my IPO branch office is situated at Melaka Kota Kinabalu, Sabah. Sarawak office is in Kuching region. Patent protection abroad. Why apply for patents abroad? As patent rights are territorial in nature, a patent granted in home country only protects the invention in that country. It does not provide protection outside. Thus, if patent applicant seeks protection for the invention in other countries, separate applications for patents must be filed in each of those countries through PCT route. Then the question arises, what is PCT? PCT means Patent Cooperation Treaty is an agreement for international cooperation in the filing, searching and examination of patent applications and the dissemination of information contained in the applications. The treaty implements the concept of filing a single international patent application which will have a legal effect of filing in the different countries bound by the treaty. The PCT system is a patent filing system and should not be mistaken for a patent granting system. Therefore, no PCT patent or international patent is granted. The task and responsibility of granting patents remains exclusively in the hands of the patent offices of the countries where patent protection is sought. The treaty allows the patent protection for an invention simultaneously in each of a large number of countries by filing an international patent application. Such an application may be filed by anyone who is a national or resident of a contracting state. It may generally be filed with the National Patent Office of the contracting state of which the applicant is a national or resident, or, at the applicant's option, with the International Bureau of WIPO in Geneva. When a PCT application is filed, it is then subjected to an international search. This search is carried out by an international search authority. The search results in an international search report and contains details of published documents that have an effect on the patentability of the invention claimed. The ISA also prepares a written opinion on patentability. The international search report and the written opinion are communicated by the ISA to the applicant. During this time the applicant may decide to withdraw his application if opinion in the said report makes the granting of patents unlikely. If the international is not withdrawn, it is published together with the international search report by the International Bureau. PCT procedure. There are two ways in which an invention can be protected abroad. It can either apply directly to those countries of interest, or use the Patent Cooperation Treaty, PCT international application. The PCT is an agreement between countries that they will cooperate in order to ease the process of applying for patents in a number of countries around the world. The system is administered by the World Intellectual Property Organization from its headquarters in Geneva, Switzerland. The PCT system enables the applicant to make a single application in own country, the international application, and then designate as many other countries that are involved in the PCT. National route. If the applicant opted national route, a separate patent application in each of the countries of interest needs to be filed. This option is usually selected if the number of countries in which patent protection is sought is very small. Otherwise, this route may prove to be expensive as well as cumbersome. International route. For those seeking patent protection in many countries, it is advisable to consider opting for the international route by filing one single international application as provided by the Patent Cooperation Treaty. This option, however, is only available for nationals or residents of member countries of the Patent Cooperation Treaty. Malaysia is one of the 141 members of the PCT, as at March 19, 2009. Phases of PCT application. The PCT application procedure, basically, is divided into two phases: international phase and national phase. International phase. The international phase, governed by the PCT and its regulations, starts at the filing of the PCT application and ends when the application enters into each of the countries of interest where protection is sought. There are 3 stages in international phase, which are as follows: filing of PCT application. As with any patent application, the first step for a PCT application is filing a formal request, which consists of the PCT request form accompanied by patent specification and the prescribed fee, with the receiving patent office to be filed in triplicate. The receiving office functions as the filing and formalities review organization for international applications. Now, what is a receiving office? The patent offices of the countries that are members to the PCT are called receiving offices. Alternatively, the international application may be filed with the International Bureau as the receiving office. In the United States, the U.S. Patent and Trademark Office acts as a receiving office for United States residents and nationals, but the International Bureau of the World Intellectual Property Organization may also act as a receiving office for U.S. residents and nationals. In Malaysia, PCT applications may be filed at the MyIPO as the receiving office. At this stage, the applicant also designates the countries of interest in the PCT request form. Second stage is international search and publication. The PCT application is then subjected to an international search to identify whether any prior art which would affect the patentability of the invention is available. On completion, an international search report and a written opinion on the findings will be issued. No official request for search need be made, as the search will be conducted as a matter of course. After 18 months from the priority date or the international filing date, whichever is the earlier, the PCT application together with the international search report is published. International Preliminary Examination. The International Preliminary Examination is an optional step. If the applicant opts for the same, the request for the examination must be made within 22 months from the priority date or their international filing date, whichever is the earlier. On filing their request, a preliminary examination on the patentability of their invention is conducted and an international preliminary examination report on the findings of the examination is issued. This marks the end of the international phase. National phase. In order for the PCT patent application to be protected in their designated countries, separate applications need to be filed in each individual country. The entry into the individual countries is their beginning of the national phase, where national patent laws will apply. To enter the national phase in Malaysia, an application must be filed with the MyIPO within 30 months from the priority date of the PCT application. The application consists of a copy of the international application, in the English language, and the prescribed form, Form 2A, together with the prescribed fee. On entry into the national phase in Malaysia, the application will be subjected to Malaysian patent laws and the same will be processed in accordance with the local patent examination and registration procedures. Fees and requirements. For filing international application under PCT and considering the PO as a receiving office, then there are 3 categories for payment. This includes transmittal fee for the first 30 sheets via online mode is 500 and manually 550 ringgit. Another one for international filing fee for the first 30 sheets is Rm 5,718. Next is search fees under Rule 16/Rule 40.2, For Australia RM 6769, Korea 5423, for European Patent Office is 8917, for Japanese Patent Office is 7024 respectively. Opposition systems. Many countries provide opposition mechanisms in their patent systems. Opposition systems offer third parties the opportunity to oppose the grant of a patent within a certain period of time provided by the applicable law. An opponent must allege at least one of the grounds for opposition among those that are prescribed in the applicable law. Opposition procedures are closely related to the patent granting procedure. An opposition may be requested soon before the grant of a patent, pre-grant opposition, in countries such as Australia, India, Egypt. Or after the grant of a patent, post-grant opposition, in some countries like Denmark, Germany, India, Malaysia. In some countries, an opposition may be filed within a certain time period immediately after the publication of the application for a patent and before the examination phase, in which case the procedure resembles, to a certain extent, the so-called third-party observation system. It is possible to combine pre-grant and post-grant opposition systems. India, for example, provides both a pre-grant and a post-grant opposition system. One of the main objectives of the opposition system is to provide a simple, quick and inexpensive mechanism that ensures the quality and validity of granted patents by allowing an early rectification of invalid patents. Pre-grant opposition often starts once the examination of a patent application has been completed by a positive result. The office publishes its intention to grant the patent on the claimed invention contained in the application, and provides a certain time period during which an opposition can be filed. The opponent shall state the grounds for opposition and submit any evidence. If no opposition is filed during that period, the patent will be granted. If an opposition is filed, the applicant will be notified of that fact, together with the grounds for opposition and the evidence, for example, prior art documents that demonstrate lack of inventive step. The applicant will be given the opportunity to comply with the requirements under the applicable law, and to make observations, within the prescribed time limit. In accordance with the applicable law, the opponent has the possibility to respond to the observations made by the applicant. Based on the submissions by the opponent and the applicant, an examiner or any other person entrusted to decide on opposition cases under the applicable law will make a decision as to whether the patent shall be granted or not. Post-grant opposition starts once the patent is granted and published. An opposition may be filed with evidence within a certain time period prescribed in the applicable law. Similar to the pre-grant opposition, the patentee will be notified about that fact, and be given the opportunity to comply with the requirements under the applicable law, and to make observations, within the prescribed time limit. Based on the submissions by the opponent and the applicant, whoever is entrusted to decide on opposition cases under the applicable law will make a decision as to whether the patent shall be maintained, amended or revoked. Thus, a patent granted on an invention that has gone through opposition proceedings would be considered as having a higher credibility in terms of its compliance with novelty, inventive step and other requirements of patent law. And finally, after lengthy and complicated procedure, patent is granted and inventor can enjoy the monopoly right. Thank you.